Welcome. This lecture forms part of the preparatory material for the Solicitor's Qualifying Examination for the syllabus area Tort Law. This particular lecture covers employers' liability. We're going to look at several topics within this area, which are listed from 1 to 9. The total study time is approximately 4 hours, but obviously that is quite subjective. It depends on you and how well you manage to cover the material. And the difficulty level here is 2 out of 5, just to remind you, 5 being the hardest and number 1 being the easiest area. And again, that's fairly subjective. So what we'll be covering in this particular area of employers' liability? Well, on this slide and the next slide, we list the topics that I'll be discussing. Firstly, we'll be looking at definitions and general principles, overarching principles that cover this area. We then concentrate in topics 2 to 5 on the general duty of care that employers owe their employees. You'll see that the general duty, the principal duty, can be subdivided into 3 different categories, and these are marked as number 3, 4 and 5. So an employer owes a duty of care to provide competent staff, an employer owes a duty of care to provide safe premises, plant, equipment, etc. And finally, an employer owes a general duty to provide a safe system of work. We then move on to standard and breach. As you know, when you discuss negligence after doing duty, you always look at the standard and whether it's been breached by the defendant. So we'll consider what a reasonably competent employer should do and how breach is determined. Once that's completed, we look at causation. Did the employer's breach cause the employee's damage? And we discuss whether the damage is too remote. We then specifically cover, in employer's liability, the type of harm that can be claimed for. There's several different types of harm that an employee can bring against an employer. So, for example, obviously personal injury, but also things like psychiatric harm in the form of stress at work. There are cases involving assaults on employees, victimization and harassment. So the type of harm is wider than we normally discuss when we look at negligence generally. And finally, we then look at general defences. What defences are available by the employer that can be utilised in cases commenced by employees against them. So, for example, valenti, which is consent, and contributory negligence, which is by far the most popular defence available. So what is employer's liability? Well, essentially, employer's liability is just a form of negligence. It operates within the workplace, and it involves employees bringing actions against their employer if the employer has been injured whilst working. Now, because it follows negligence, it follows the exact same structure as a general negligence claim. So duty, breach, causation, remoteness and damage. It also means that we've covered an awful lot of the cases already. You might remember, for example, a case called Paris and Stepney Borough Council, where Paris brought an action against his employer, that's Stepney Borough Council, because whilst he was working on a lathe machine, he got a splinter in his eye. And you might remember as well, he only had one good eye. The other eye had already been damaged during the war. He claimed against his employer, stating that the employer should have ensured that he wore protective goggles, particularly because the employer knew he had one good eye. And that's just one example. There are many cases we have done that come under the area of employer's liability. So hopefully while we're doing this, a lot of it will come back to you, which does make it easier in terms of studying. Now do note this area overlaps with a lot of other areas of law, primarily employment law, and in particular the employment contract. So often I'll be making reference to contractual elements here, but also health and safety law. There's lots of law governing health and safety within the workplace. Much of the law is actually criminally based, meaning that if an employer breaks these laws, they're actually punished in the courts. So it's a form of criminal law. A typical example many of you might know already, if you work, for example, part-time, you might notice that in fact often on notice boards in the workplace there is an abridged version of the Health and Safety at Work Act 1974. This is known as HASAWA. Now this is not a civil liability act, this is very much a criminal act. and states that basically if the workplace is not kept up to certain standards of safety, health and safety, then the employer can be prosecuted. Obviously in this area we're going to be looking at civil law claims under tort law. Employers' liability is one of the oldest forms of common law action in the law of tort. It's got a very long pedigree. It was recognised many, many years ago that employers owed a duty of care to their employees, or if you want to use the old vernacular, masters owed a duty of care to their servants. What's interesting though, that since Donoghue there's been a massive growth in this area. There are an awful lot of claims commenced each year under the area, or under the remit I should say, of employers' liability. So let's have a look at some general principles in this area. As I pointed out, the common law duty is well established. Originally, the duty in tort law was very much based on the contractual relationship between an employer and an employee, or master and servant. And this was especially true in relation to the implied terms. Now that particular area will be covered in contract law rather than in this area of tort law. One of the main reasons why actions in employers' liability is so common is because all employers are required to have compulsory insurance. Under the Employers' Liability Compulsory Insurance Act 1969, every single employer in this country has to have a minimum liability insurance of £5 million. It effectively means that if a claimant, an employee, brings an action, they know that even if the employer goes bankrupt, there will be an ability to meet a financial judgment from the courts. Effectively, the insurance company will pay out. So just keep that in mind. In these cases, when actions are commenced against employers, in reality, it's the insurance company that deals with such claims. Now, many of the original tort law provisions have actually been incorporated within areas of criminal law. As I mentioned earlier, one of the famous examples is the Health and Safety at Work Act, or HASAWA 1974. You are not required to know the statutory provisions in this area. There are an awful lot of them, as you can imagine. You should be aware of them, and obviously you'd need to research them if you were bringing any action using them. But in terms of knowledge for the solicitor's qualifying exam, you're not required to know any of the detail in those areas. So what is the duty that an employer owes to their employees? Well, the principal duty is that an employer is responsible for the health, safety and welfare of all the employees under their care. Now, it is one single duty as far as the courts are concerned. They don't split it up into component parts, but for the sake of studying it, it's easier to do so. And as you can see, we've divided it into three parts here, three categories of the principal duty. Firstly, a duty to provide competent fellow employees. Secondly, a duty to provide safe plant, premises, equipment and so on. And finally, a duty to provide a safe system of work. So an employer owes each one of these. Now you'll quickly determine that the first two are quite specific. The duty to provide competent employees and to provide safe plant, premises, so on. They're quite specific in their remit, whereas the last one is very generic. It basically catches everything not in the first two. Some even argue the last one is actually the only one you need because the other two are incorporated within it. It's also important to note that as far as the courts are concerned, there is only one duty. They don't subdivide it like we're doing it here, which explains that you'll find that many of the cases overlap the areas quite a lot. It's artificial as far as the courts are concerned to divide them into these groups. But nonetheless, as I pointed out, it's much easier to remember this material if you do so. Many cases have talked about the general duty of care on employers towards their employees. But probably the most famous, the seminal case in this area, is the House of Lords decision in Wilsons and Clydencoll and English in 1938. The facts are actually not that important. It concerned the claimant who was badly injured by some machinery down a coal mine. He was crushed by one of the little coal trains they had down there. Now, in this case, the House of Lords gave the duty, principally Lord Wright. He described it as one single duty on an employer towards all their employees. As I said, subsequent to that case, it's been subdivided into the three elements I mentioned a bit earlier: the duty to provide competent fellow employees. So let's go through the duty in a bit more detail by looking at its individual component parts. I'm going to start with the first one, which is the duty to provide competent staff. What does this mean? This means that every employee would expect other employees to be competent to do their job. So if, for example, they do their job badly, negligently, and the claimant employee is injured, they can sue the employer. Now, they can technically, in theory, also sue the fellow employee. That actually would be highly unlikely in practical circumstances, simply because the chances are a fellow employee, you may win your case, but in fact they're unlikely to be able to meet any judgment made against them. Remember, employees are not generally required to have insurance. Some are, but the vast majority of employees do not have their own personal insurance while they're working, whereas employers do, as I mentioned earlier, under the Employers' Liability Compulsory Insurance Act 1969. The second category of the duty involves the employer providing safe premises, plant, equipment, machinery, and so on. So this is effectively making sure that any tools that an employee uses are safe. So as you can see in the picture there, like a forklift truck or a ladder, or any protective equipment like goggles or boots or a hard hat. Now this does overlap a lot with the last category we're going to do, which is the safe system. So a lot of the Now, as I mentioned earlier, this last category, the third category, the duty to provide a safe system of work, is really sort of a catch-all category. It's a generic category that covers everything not included specifically in the first two categories that we've looked at. So it includes, amongst other, one of the most important aspects of this particular category is training. Training must relate to the task that the employer requests the employee to do. And